All right. Well, good morning, guys. Thanks for checking in. I'm the chief of the Iowa regulatory section here in the Rock Island District. I noticed that we had some people from other districts on here as well, so my assumption is you're probably from neighboring states. If I haven't met any of you guys, I've been in regulatory for about 5 years, been a core employee for about 11. So this presentation is mostly a 101. I'm not too familiar with how advanced your knowledge is with the regulatory program, so I'll hit the basics quickly. Most of the questions that come about will give you a little bit deeper input as far as what we go. I did see Keith McMullen on here, so if you have something in the St. Louis district, he is definitely going to be a contact. Again, this is our Rock Island viewpoint, so if you have questions, by all means, contact your local regulatory district. We have a reference at the end where you can go look up web pages in regards to each district that you're in. So with that, we'll get started here. Some of the objectives of this, what is the Clean Water Act, which streams, wetlands, and water bodies are regulated, what do you have to do to apply for a permit, and what are the types of permits and guidelines for those, as well as we're going to reference some stream mitigation and wetland mitigation requirements as set forth in 33 CFR. All right, so the Clean Water Act, for those that are unaware, was established in 1972. Basically, it's just something that it sets into place what regulates the act of placing discharge or fill material into a water of the United States. The main goal is to make sure that we have clean water. I know there's been a lot of discussion lately, especially over the last few years with WOTUS, and this law is kind of the backdrop for all of that. We regulate pretty much any water right now that has a connection to a traditionally navigable waterway, which we'll get into later. We are actually responsible as the Corps for carrying this mission, if you will. Our partner agency, the EPA, does the enforcement side of this law, I guess, and we do the compliance and then the permitting. So what constitutes a discharge? It could be anything from actually dumping material into a wetland, like in the bottom right corner, the truck dumping fill. It could be a bulldozer going over ground, messing up the stream bed of a stream. If you see in the lower left corner, they went through with a bulldozer, took down trees, and created a discharge. So fill that I referenced there is this is directly from the CFR. Fill is any material that has the effect of replacing an aquatic area with dry land, increases the bottom elevation of a water body or wetland, or changes the use of a water body. So this will include rock, soil, dirt, or any other similar materials. Most of you are obviously familiar with what fill material can be, but in this case, this is what it is specifically in the CFR. So where does our jurisdiction fall in? Our jurisdiction we have two different types of jurisdiction. We have the geographic jurisdiction. So geographic would be, is it in a wetland or water body that has an ordinary high water, or a stream, that has an ordinary high water mark and a defined bed and bank, or is it a wetland that is adjacent to or abutting one of those streams that has a direct connection to a downstream TNW, traditionally navigable waterway. There's also two laws that are in place with this. Section 10, which is the Rivers and Harbors Act. That one is mostly your big rivers, something that has been traditionally navigable for a number of years, had commerce on it. That is like the Mississippi River, for example, in our area. Iowa actually only has two. We have the Mississippi River and the Des Moines River. A very small portion of the Iowa River is at the very mouth of it, and obviously the Missouri River as well. Illinois has a few more. and I'm not too familiar with Missouri as far as what their TNWs or Section 10s are. So our regulations for stream, like I said, here's the navigable waterways. These are commercial navigation, and there's the ones I just referenced. Those are your main, the obvious ones. Those are the areas where we have no doubt, public knows about it. There's really hardly any major issues. The big issue with those is we generally do have real estate and federal lands or projects associated with those. So there are other entities and other, obviously with Coast Guard being on the line, they have a major say in that as well. Perennial streams, which all of those are for navigable waterways, they always have flow in a year-round basis. They're generally a solid blue line on a USGS topo map. Not always, but mostly. And generally they're named. It could just be something as a ditch. It could have a name like, or not. Sorry, it's not a ditch, but it could have a name, a bull ditch or DD something. Those are generally your perennial streams, and those are areas where you'll always see water on a yearly basis, except during extreme drought. That is a different case. We also have jurisdiction over intermittent streams in Section 404. And these streams, they'll flow for a long period of time, and generally you'll see water in them for 7 days or more after a normal rain event. They don't always have water, especially during drought times or periods of the season where you're not actually seeing a lot of rain, maybe in the middle of the summer or August. They may not have water in them, but they do have a wet season, and so usually you'll see water in between the winter and spring, but also then towards the end of the season. This July was a weird year as far as precipitation goes, but most of these intermittent streams actually looked probably perennial in that situation because they had so much water. And oftentimes, they'll come up as a dotted line or a dashed line on the USGS topo maps. Some of them are named, some of them aren't. It's not really relevant as far as our jurisdiction goes, but they will generally show up on your USGS topo maps. And then the hardest one to identify is ephemeral streams. These are really far up in the reaches of the the watershed, and oftentimes most people have a hard time differing between these and erosional gullies. The big difference is that we have to identify an ordinary high water mark and a defined bed and bank in order to call these jurisdictional. And the big issue is there's generally not water in them when you actually go out to look. They're, by definition, they only have flow after precipitation events, and they'll generally only hold that water for maybe 2 to 7 days. I mean, it's usually a pretty short period unless you're in a very rainy time. Sometimes in April, these ephemeral streams will look intermittent because they'll get several rain events back to back. These are almost always unnamed. Some of them are named, but mostly unnamed. And they also show up as a broken line or dots on the USGS topo map. So again, how do we identify whether or not these are jurisdictional? The perennial streams, it's usually not an issue. Most people can understand, those streams have a direct connection downstream to a traditionally navigable waterway. But in the intermittent and ephemeral, it gets a little bit more difficult. So what we look for and what is required is an ordinary high water mark, which could be like a defined line on the bank. You can kind of see it in this picture. It looks like there's a line kind of about halfway up. That would generally be considered the ordinary high water mark. And then it needs to have a defined bed and bank. So a defined bed and bank, it'll have sorting of material. You'll have, gravel or sand, depending on where you're at in the state or what your sediment is around there. And then it has to have a direct connection to a navigable waterway. That would be downstream. So, the things that we look for when we find a jurisdictional stream are actually the quality of the stream. Is there a significant amount of fish habitat, or is the water clear? Is it brown? Stuff like that goes into effect when we get further down the permitting process as far as impacts and mitigation. We also look for meanders. A lot of streams in Iowa have been straightened, and so there's a lot of very straight man-made and artificial channelization. So we take that into consideration when we get into the permit process. There's also other bodies of water. You have any old quarries, ponds maybe that were created by putting an impoundment over a stream. And the main thing is they're only jurisdictional if they have connection to a downstream TNW. That still holds true here. So if they are connected to a waterway, or they have a spillway that connects to one, they would likely be jurisdictional. In most cases, they come back that they are. It's very rare, unless you're in the prairie pothole region of Iowa or even probably the Dakotas, to actually find something that doesn't have a direct connection, because you need the water to provide itself from the drainage area. It's got to go somewhere usually. That being said, there are definitely cases where you could find a stream that is not, a pond that is non-regulated. Contact your local regulatory department and find out through them, because they will actually make that call. The Corps we are the only ones that can say something that is or is not jurisdictional. So ultimately, contact your local regulatory branch or department. So that's it for streams. Getting into wetlands, it has to meet the three-part test. So when we look at wetlands, we look at the vegetation. Is it hydrophytic in nature, or is it plants that are generally found in uplands? We have to look at the soils to identify, are they hydric, or do they have hydric characteristics? And then obviously the water, we have to make sure that there's hydrology. For it to be a wetland, it has to be wet, usually. The 87 manual has definitions for each of these, and has a manner of how you actually go about inspecting these characteristics to determine whether or not something is jurisdictional or is an actual wetland by our standards. There are mainly three different types of wetlands in our region, but the most common one seems is emergent wetlands. Emergent wetlands have non-woody vegetation, and they have, some we consider scrub to be similar to emergent. It doesn't have a forested habitat, but it's generally dominated by perennial plants, and it has rooted hydrophytes that are perennial in nature, obviously. Forest, everybody knows what a forest is, for the most part, but a forest in this regard is generally going to be close to a river or stream in the floodplain. Not always. Sometimes there are areas where we have, jurisdiction in a wetland that pops up somewhere that's not actually in a floodplain. But the soils are usually wet during the spring and summer months, and sometimes if you have a low precipitation year, they'll actually have dry soils. So that's where the soil testing itself actually comes in, because when you go out and you do a determination for jurisdiction, you may actually be going out in a time where none of the factors are actually in place. You're only seeing it as one day across an entire year. So hitting it right on the same day where you're actually going to see water can oftentimes be problematic. The wetland itself, to be jurisdictional, needs to have water for 14 days in a growing season. So if you hit that 14 days, that's good. It's a good identifier if you hit all 14, but sometimes as a regulator, it's hard to actually get out there during that period immediately after a rain event or whenever to identify. So another common factor, obviously, I saw there were some agricultural people on here. We have farmed wetlands. So usually farmed wetlands will show up in the middle of a field that have ongoing farming activity, and the farmers generally will plant through them to try and get a crop out of them, because during dry years you probably could. During a wet year, obviously, as this picture shows, the vegetation won't take as well. They exhibit wetland criteria, so they still have to meet the three-part test of hydrology, soils, and plants. And they usually have about, well, in this case, they have to have 14 days of water or meet hydrology for 14 days to meet the jurisdictional status. So the main thing is if the crops were actually stopped and the agricultural activity stopped, the hydrophytic vegetation would return. That's a key factor here, because if it doesn't actually have hydrology for enough time, it won't actually have hydrophytes. So what types of waters are not subject to 404? We have isolated wetlands, which farmed wetlands can often be if they don't have a downstream connection. And we have ponds that could potentially not have a surface connection to a jurisdictional stream. Stream segments with no surface or hydrologic connection to a jurisdictional stream. Grass waterways. Grass waterways are usually put into a field where there was historically either a stream or an erosional feature, and those grass waterways themselves, after it's been done, are not jurisdictional. Along roadside ditches, you have a ditch that was placed in uplands to drain wholly uplands. That is not under our jurisdiction. It can be used as a conduit, however. So if there was a wetland that was located, say, adjacent to a ditch, and it directly connected to a downstream stream or downslope stream, that could potentially be a jurisdictional wetland. And then also stormwater and other man-made treatment ponds. So what we have here is a map. This is just I'm going to go kind of through an example of how we would look for jurisdiction as regards to wetlands go. So if you look on this map, you can kind of see some stress on fields. I don't know. Can you guys see my mouse, Angie?
Yes, I can.
Okay. So this one here, obviously you can see some stress, not so much stress on the bottom right, wetland 1-1. Excuse me. And then also up here where there is a grass waterway or something that, or even maybe an erosional gully, you can see stress in areas. In the middle of the field, there's obviously nothing that really shows itself as potential, just at least from a desktop view. When we look at LIDAR, you can see this wetland 1-4 kind of has a ring around it, so there's no way really for the water to get out, or it doesn't appear as though it does in this picture. And similar to wetland 1-5. Wetland 1-1 does look like there may potentially be a little bit of a connection right here, but this is obviously only 1 year's LIDAR worth, so it's kind of hard to just go straight off of LIDAR. 1-3 and 2-1 have a direct connection, and you can see it as it continues down. Looking back at, so when we do these, we try to find multiple years, so we're not just looking at one timestamp. There's multiple years worth of data as far as aerials go. So when we look here, this wetland here is isolated on the left side, both of them likely, because there's no direct connection. We know that, I know because I found this picture, but this year is a very wet year, so it's a good, it has a pretty good tell as to where water's going, because we do know that this was a very wet year. I believe this might have been 13. And then you can see that the 1-3 and 2-1 do have a direct connection, similar to what we saw in the LIDAR. And the one that was in question, 1-1, it does have a connection that continues over to this grass waterway, which then continues to go downstream. And eventually, there is a stream downstream of this wetland. So the LIDAR is a good first start for us, along with aerials. If you see a direct connection, likely it's going to be a jurisdictional wetland. Are there any questions at this point with jurisdiction or stream types? Okay.
If you do have a question, just remember to *6 to unmute your line so we can hear you. Otherwise, just put it in the chat box and I will pass it along to Matt. Back to you, Matt.
Okay. So for the Corps folks, we obviously don't issue ourselves permits. However, because we are a federal agency and we have to comply with NEPA, we do have to meet the general conditions and conditions of the permits that are in place as well. And same thing for individual permits, need to do alternatives analysis and LEDPA, similar to what a project would do or what a permittee would do as a public entity. So the nationwide permits are issued every 5 years. And we have a requirement to get those done within about 60 days. There is a condition in the nationwide permits that a project that has a PCN, if it's not done or you have not received anything, but you believe you fall within the general conditions and would otherwise be issued that permit within 45 days, you do have the right to proceed without our input. That usually does not happen. Usually we're in contact with these folks or with you guys, so it's not too much of an issue. But if it were an issue, if it is a PCN required after 45 days, if you believe you meet the general conditions, you may proceed. Now, you're still subject then to us coming back and disagreeing, but for the most part, like I said, that doesn't generally happen. We also have a 401 requirement, water quality requirement. In Iowa, that's the Iowa DNR. In Illinois, that's the Illinois EPA. It's their water quality department. And then, some projects will actually require a individual state 401. In Iowa, at least, we have a certain amount of outstanding Iowa waters, and those are waters where it's been a known area of high-quality water. Okoboji, if you've ever heard of Okoboji Lake, is a natural, very clear, very high-quality pond. There's also streams and areas where there's been identified degradation and issues, or maybe even a trout stream that's been identified. Some of those come up as outstanding Iowa waters. The nationwide permits are reissued every 5 years, so the most recent ones came out in 2017. So the next round or next batch will be issued in 2022. There's 53 nationwide permits right now. That number could go up, it could go down. I believe there's a couple numbers in between that aren't used or were historically used, so that's why they aren't anymore. And if you need to find those, they are put in the Federal Register every year. We also have regional permits. Missouri, Illinois, and Iowa, we all have our own. Those are general permits, but so the NEPA, or not NEPA, the alternatives analysis and 404B1 review has been completed just like the nationwide permits. So they're much easier to process, and they actually are a lot easier for the applicant to go through. You don't have to go through the NEPA analysis because it's already been done. You don't have to go through a public notice and or the LEDPA or alternatives analysis. That's the big difference between individual permits and general permits. So just some general ones. I won't spend too much time on this because this presentation was actually more for a public entity, I guess, if we go to a presentation in the public. But main ones for you guys: maintenance. Anytime a culvert or bridge or something is replaced in kind, and there's very minor changes, that would be an example of a situation for maintenance, or bank stabilization. They had issues with the rock falling away, or it's old, it needs to be replaced. Those are good examples of maintenance projects. It needs to be a structure that, I guess, if there's been any changes, they need to have minor changes in them. I know minor is subjective, but and some people could say minor is much more than what I would. But the main thing here is, if you're really not changing the use or the purpose of the structure, and you're staying pretty close to what was already there, it's really not much of an issue, and we would generally consider that maintenance. If there's damage that's been done by a storm or some kind of activity, a flood, it must be repairable, and it should be done within a reasonable time. We usually say about 2 years after a storm event, and that's actually, I think that's referenced in the nationwide permits as well. Not all nationwide permits need to be sent in to us. There's definitely some situations that we receive a lot of permits that are unnecessary for us to even review because they don't have a pre-construction notification. In this case, nationwide permit 3, the only time when this is really necessary for us to see something is if the impacts occur in a special water, which includes wetlands, bogs, fens, riffle pool complexes, or Section 10 waters. Nationwide permit 13 is a very common one as well for bank stabilization. This is everybody really knows what bank stabilization is. I mean, it's rocks, it's gabion baskets. You could have stone toe protection. There is the availability. You can use broken concrete. It can't have any protruding rebar or any other structure sticking out of it, and it can't be larger than 3 foot in either direction. If there is rebar, it needs to be cut flush so that it's not sticking out from the cement. There is a 500-foot limit for this nationwide permit, and it can't exceed 1 cubic yard per running foot. Now, that being said, we do allow for some projects over 500 feet. If we believe that the project is minimal in impact, we could apply a waiver that takes coordination with EPA and all the other agencies that are in our region to make sure that nobody has any real heartburn over it, or just to make sure we're still falling in line, in their opinion, with the Clean Water Act, not Clean Water Rule. Most of these have a non-PCN requirement as long as it's under 500 foot and you're not putting discharge into a special aquatic site, which are the wetlands, riffle pool complexes, etc. And if the discharge is less than 1 cubic yard per running foot below the ordinary high water mark. Those situations, we don't need to see anything. We do receive a lot of these that we don't need to see, like I said, and we have to respond if we get something in writing. So in the future, if you have questions, again, call your local district because you may have a regional condition that is different. I know in Iowa we don't have a regional condition that limits our use of the waiver for this. However, there is a regional permit in Illinois that has a 1,000-foot limit for it as well. So you may have a regional permit that does the same thing as nationwide permit 13. It just allows for more. So check with your local regulatory district on that. Probably I won't dwell on this too much, but residential developments, anytime there's a subdivision or a single-family home, something like that needs to be put in. The discharge can't exceed a half acre, and it can't exceed 300 linear feet of stream. The 300 linear foot of stream does have a waiver ability if it's an intermittent or ephemeral stream, and that carries through on most general permits as far as the nationwides go. A perennial stream has a hard 300-foot limit as far as when it can be applied. And all of these need to be sent in for pre-construction notification. Construction for commercial developments is very similar to Nationwide 29. It has the same thresholds. It's half acre of waters of the U.S. and 300 linear foot of stream. It does have the waiver ability for anything over 300 if it's intermittent and ephemeral as well. And all of these need to be sent in as a pre-construction notification requirement.
Hey, Matt, we do have a question that maybe we should address before you move on.
Okay.
It said that you touched on when ditches are not jurisdictional. However, can you expand on when ditches are considered jurisdictional, and if they are, what does the Corps require?
Okay. So ditches, so a couple things. One, a ditch, you could have a named waterway that is called a ditch, and in that case, if it is a stream and has an ordinary high water mark and a defined bed and bank, then it would actually be, obviously, it would be a stream and be considered jurisdictional. In order for a ditch to be jurisdictional, it can't be something that was built, if it's non-jurisdictional, it needs to be built wholly in uplands to drain only uplands. And what that means is, you're just your roadside ditch go out to a rural area. You got a road going there. They put in the road. There's a ditch associated with it to keep the water off of the road. That is generally not jurisdictional. The only time it would be jurisdictional is if it exhibits a ordinary high water mark and a defined bed and bank and contributes flow to a downstream TNW. They could, however, be used as a conduit to consider something as a surface water connection. So if you have a wetland on one section and there's a ditch and another waterway, if that's a direct connection to a waterway, that could potentially be considered jurisdictional. If that doesn't answer your question, my phone number will be at the end here, so you can call me. Okay, so we've covered the general permits. If we get into the individual permits, again, core employees kind of disregard this, although we do have to meet all the conditions and still follow the process that is required for individual permits with public notices and the LEDPA requirements, the least environmentally damaging practical alternative. So an individual permit is very in-depth. We have to go through the whole NEPA process. We have to go through alternatives analysis and a whole gamut of information that we cover with the nationwide permits and regional general permits ahead of time. That's why they're so much easier. Your general permit processing time can take anywhere between 30 to 45 or 60 days. These standard permits usually take between 60 and 120, and that's only if there's no changes and we get a complete application. Generally, where these come into play is if you exceed the half-acre limit for a nationwide permit or exceed the stream loss limit of 300 feet for streams with a general permit. Or if your activity doesn't actually fall within the lines, the threshold of, named activities such as mining or something like that may not actually have an activity that has a nationwide permit associated with it. Maintenance dredging, for example.
Matt, we have one more question.
Okay.
When it comes to bank stabilization projects, when do you use a nationwide 3 versus a nationwide 13?
Okay. So nationwide 3 would be applied only when you're repairing a bank stabilization site. So if you have one little area that needs to be fixed, or even if it's a large area, if it's a previously serviceable structure is the main thing. So if we had authorized something to be put there and you just need to replace the rock that's already there, we would generally consider that just to be a nationwide 3. Nationwide 13 is generally if there's going to be some kind of change, whether it be more rock as far as depth-wise, if you get close to that 1 cubic foot or cubic yard per linear foot, and then also if you're making it longer or it's a new area where bank stabilization hasn't been previously implemented. Okay, so stream and wetland mitigation comes into play. For wetlands, when you exceed 1/10 of an acre, so 0.1 acre of wetland loss, that will be a requirement for mitigation by any applicant or permittee. Generally, this is where we take into effect the quality of the stream or wetland that you're impacting. Oftentimes, 1-to-1. Excuse me. Oftentimes, 1-to-1 is okay for very low quality wetlands. farmed wetlands generally fall into that 1-to-1 because it's such a low quality of wetland. When you get into the forested wetlands or other higher end values, I mean, it could go anywhere from 1.5 to 3 or even more if it's a fen or a bog or something where it is not really replaceable. Streams, for Iowa at least, we have the stream mitigation method for Iowa, which was just revised. We have a stream mitigation method in both Missouri and Illinois as well. So those would be your go-tos for stream mitigation as far as those states. I'm not going to read all of these because this would take forever for me to get through everything, but there is a set of requirements that has 12 different things that we have to identify with any mitigation plan. You can read all these at your disposal if you want, but basically we need to know everything you're doing, and then that way we can adequately make a decision as to whether or not it's going to offset the stream or wetland loss associated with your impacts. Threatened and endangered species, so Section 7 activities, which will require any form of take. Take can be anything from actually killing to bothering and touching endangered species. A federal activity that, so a nationwide permit or any kind of permit that allows you to do an activity, we have to take into account whether or not there's going to be endangered species affected by your activity. If there is going to be take, we have to consult with Fish and Wildlife Service and potentially go through, biological opinion. Could potentially be a not likely to adversely affect. For example, with bats, Indiana bats in Iowa, if the trees are cut down from October 1st to between October 1st and April 1st, in the winter, basically, we know the bats aren't there. And so generally that's a not likely to adversely affect depending on where it's at. That's not true if there's a roost tree or something like that that is known. But that's just an example that we use as a not likely adversely affect. So as I said, take is, harm, harass, pursue, hunt, shoot, wound, kill, trap, capture, or collect, or attempt to engage in any such conduct. Basically, don't do anything to an endangered species unless, don't even breathe next to one as far as their federal law goes. It's a very tight rope, and they don't have very much bending room. So if you have a project that could potentially affect endangered species, definitely need to talk to Fish and Wildlife. We, as a federal agency, will make a determination, and then on the permittee's behalf, we will actually conduct this federal to federal. Another part of our law is Section 106, which is the National Historic Preservation Act. If we have a project that could potentially impact something that is cultural in nature, we will often require a Phase 1 survey, or if a Phase 1 has already been done, to determine whether or not a project would impact a historic property that's eligible for the National Register. If something is found, could potentially go to Phase 2, which includes, as this guy is showing here in the picture, digging stuff up. A Phase 1 generally just has single probes and then walk in the actual site. All activities that are done with this for a permit, they need to be done before a permit can be issued. We can't actually put in a condition that it needs to be done. It has to be done prior to issuance of our permit. In Iowa, we've talked to the State Historical Preservation Office, same thing for Illinois. And again, that is a federal, we as a federal agency have to make that determination and pass that determination to them for concurrence. And if they don't concur, then we go through the consultation process and work through that with the permittee and our office. We actually in Rock Island do have an archaeologist in our office. It's been very beneficial. It's pretty easy to just go talk to him and not have to take a guess or try and get a hold of the State Historical Office. So if you have any questions, our archaeologist here, Brant Volman, is a pretty good contact. So the EPA comes in with the enforcement side of the Clean Water Act. They can require fines and remedial action with a fine as well. And in some cases, they actually go to criminal penalties. Where this would take effect is, a violation where, for penalties anyway, a violation where somebody knowingly or willingly did something, or it's egregious in nature. Those are activities that will generally be forwarded straight to the EPA. We try to cover everything in-house as best we can, and if it's not too bad, as far as somebody who's a repeat offender or something, we'll try to keep stuff in-house and just get restoration or do an after-the-fact permit. Where the Corps comes in is really only in compliance. So something we've already permitted, that would be compliance. If we have, say we've issued a permit for a subdivision and they didn't do their mitigation, or the mitigation's failed, that would then fall in our hands, and that would not be a violation because we'd already permitted it. In that case, there is the chance of administrative penalties. That has to go through the Department of Justice, so it's a very long and painful process. We mostly just go for remedial action. If there wasn't a mitigation bank in the area at the time when the permit was issued, but there is now, we would potentially just allow for purchase of credits. But that's really all based off of the permit that was already issued. And then here's the reference page that I was talking about. This is a website link. Just copy and paste it into your address bar, whichever district you're interested in. And that's all I got.
Okay, great. Thank you, Matt. Hopefully everybody found that beneficial. I am going to open up the phone lines. I'm going to take unmute off, and then you guys are free to ask additional questions.
Hey, sorry, this is Coast Guard. I do have just one general question. So just for mine, and this is more of just, I think, the phrasing and how it's versed. So I understand a nationwide permit, but I guess where does the Section 10 come into that? So you can have a nationwide permit and then also be required to do a Section 10 review, right?
Right. So we would do them concurrently. So the Section 10 and Section 404 permits would still they'd be tied together in the same. We do the review at the same time. So if Section 10 would only apply if there's no discharge. So if there's no discharge of fill or dredge material, but it is a traditionally navigable waterway, trying to think, maintenance dredging is sometimes just a Section 10 only because there's no discharge back into a wetland or water. That would just be a Section 10 permit. If there is a discharge, we would do them concurrently. So bank stabilization on the Mississippi River. That would be a Section 404 and 10 permit if there was fill going into the Mississippi River.
Yeah, thank you. Appreciate that. And then I was just going to maybe just a note for the enforcement, I think the enforcement slide. So the Coast Guard does have jurisdiction too, and we kind of split it with the EPA, whether it's inland or not. So that's another, I think you had EPA responsible for enforcing the Clean Water Act. The Coast Guard can help with that as well, based on the jurisdiction.
Okay, thank you.